please the court. My name is Maitreya Tomlinson, and I represent the remaining appellants, Bace Services Incorporated, Stephen Bradley Morton, JTL Staffing and Payroll, and Payday Solutions. I've got a limited amount of time. There's a lot I could talk about here, but I'm going to start with a couple of errors that the trial court made, both factual errors and legal errors. And the first I'd like to talk about is the trial court striking JTL's jury trial request. Now, as we all know, the right to a jury trial is a fundamental right, so it's one of the sacred ones that we have out there. And to take that away, it's got to be knowing and voluntary. Now, the court didn't give its reasons why it struck the jury trial request, but we can look at the grounds that, and I'm going to call Franlink Link, just to be consistent with the briefing. We can look at the grounds that Link put forward to the trial court and obviously convince the trial court. And it really looks like, if you go through the record, that the court got hung up on this concept that JTL and the Bace defendants, and I'll call the Bace defendants, those are the signers of the franchise agreement that has a jury trial waiver in it, and Bace Services, which is the franchisee here in Florida. It got caught up in these concepts of...
There's a fundamental question that you ask before you get to these issues, and that is whether the parties were bound by the forum selection clause. And if you concede that, are you conceding that?
No, absolutely not.
Well, then why do you even get to the other? I mean, it seems your primary argument is we are not bound by anything.
Of those, right. Well, you could still be, you know, I guess in some instances, if the facts supported it, you could be bound by the forum selection clause, and then the jury trial waiver would come into play. But if you'd like me to jump into the personal jurisdiction, I'd be happy to.
Your argument,
yeah.
It seems to me, if you are a non-signatory to a contract, and there is no theory by which you can be made a signatory to that contract, then you are not bound by any terms of that contract.
Right.
And I thought your argument was that you were not bound by the contract at all.
Right.
Because the doctrine of closely related to was not applicable. And if you win that point, everything else falls away.
That's right. Absolutely does. The reason I started with the jury trial piece is I just think that, well, jury trial, it's a fundamental right, whereas there are constitutional concerns built into the personal jurisdiction piece, but I think that the fundamental right sort of outweighs that. The trial court got it wrong in a couple of ways. And one of the ways is that if it looked at the law a little closer and looked at the law from this circuit, it would see that while not dead on, the circuit has had a fair amount of jurisprudence concerning arbitration clauses, right, and whether non-signatories are bound to it. And ultimately what the court did here was decide that a signatory can invoke these clauses, both the jury trial waiver and this forum selection clause.
Counsel, let me confirm. I think Judge Jolly asked a very important question. Your argument is that those clients that are not signatories aren't bound at all in any respect, whether it's the jury trial, whether it's the damages, attorney's fees, whatever have you, not bound at all.
Right,
before we get into personal jurisdiction, the contract has nothing to do with those parties. They're strictly alleged tortfeasors.
Just the non-signers, right? So
correct. Is that a fair statement of your argument?
Yeah, I'm definitely saying that
okay.
the court didn't have personal jurisdiction here based on the forum selection.
All right, that's what I understood, but your answer to Judge Jolly's question didn't seem as definitive.
Okay.
Go ahead.
Yeah. So anyway, if we look at the law, we've got what the trial court probably based it on was Link had put forward this case from the Third Circuit called Tresinda versus Daimler Chrysler. And in that case, the court said, well, you know, non-signatories can bind a signatory to a contract, to a jury waiver, if they're officers or directors. And the reason the court did that is, you know, they want to preserve the value of a contract, but also they don't want a signer of a contract who obviously had agreed to this jury charge waiver to be able to circumvent that by suing agents or officers of the company, right? In the same case, however, the court indicated that it wouldn't do the opposite what the trial court did here in terms of letting a signatory invoke the waiver against non-signatories, in this case, JTL here.
I mean, it just seems to me that it all falls on whether there's personal jurisdiction over these defendants. And there's personal jurisdiction of the court over these defendants only if they are bound as non-signatories. And they're bound as non-signatories only if they are somehow connected with the contract under the theories of closely related to the parties. And that's the whole argument of the case. I mean, if you are bound by the contract, then you are bound, and you don't have any say, it seems to me, about whether it's a jury trial or not.
If you're bound.
If you are bound by the
Right.
contract. And
Well,
so you're starting out your argument like, I'm bound by the contract, but even if I'm bound by the contract, I can object to the jury trial. Is that
Well, I apologize if I'm not clear. No, I'm saying that the non-signatory defendants here are not bound
okay?
to these.
Do you, if the law is such that you're under the closely related theory, you are bound by the contract. Do you, and that you are as bound to the contract as the signatories are, then do you concede that all of these other issues go by the side and that you don't have any argument about whether you can object to the signatory waiving jury trial?
No, among other things, I think we've got an argument that the jury trial waiver itself didn't survive termination of the franchise agreement. It's an argument I make in the briefs too. So there is a scenario whether if you're bound by the forum selection clause here, if the clients are, then still the jury trial waiver wouldn't be applicable.
Man, I think I see what you're saying now. I mean, that even if you are bound by the contract, that doesn't mean that you are bound to the decision to waive the jury.
Right, absolutely not. And in this case, there's a good argument here, right? Because we have to apply the rules of how to interpret contracts. And if we apply those rules, we see that in the case of the forum selection clause, it specifically says it survives termination. Whereas if we look at the jury trial waiver, it doesn't have the same language there, right? So obviously the parties wanted to agree that the forum selection clause survived termination, but there was some reason that they didn't agree that the jury trial waiver survived termination. Now, Link is argued in the briefs that, well, it does because naturally you're going to have a jury trial that's got to. But the argument doesn't really hold weight because you don't have to terminate an agreement to sue somebody under a contract, right? You can sue them under breach without ever terminating the agreement. So now, also, I just want to get a little bit more into this closely related doctrine. And obviously, we're urging the court not to adopt it. And this is a doctrine that we're seeing in some of the district courts here in the Fifth Circuit. It's a doctrine that you see in several, Ninth Circuit and some of the other circuits out there. Some of them have adopted it, although there appear to be different versions. It looks like that the district courts that have adopted it here in the Fifth Circuit.
But all of the circuits have gone the same way, right?
In terms of one of the versions are closely related. Yes, absolutely the one, where they're sort of looking at whether you're closely related in terms of being a successor or an owner of a company. The second sort of subset, I called it, and I tried not to be too confusing in the briefing, but this inextricably intertwined concept seems to be sort of an expansion of that isn't supported by the other circuit.
The Texas Supreme Court has said, although this court has not previously addressed the matter, other courts have held that the transaction participants may enforce a valid selection clause even if they are not actual signatories to the contract. And then it goes on to say that this is essentially the same thing as being bound by the parties. I mean,
right. Well, it doesn't. There's a couple of good reasons why. Once again, this touches on some constitutional concerns. And while I value everything the Texas Supreme Court said, obviously I think we should probably focus on federal precedent here. There's this thought that we don't want to give courts too much power over people, right? And this, while closely related, that concept, it can be defended pretty well because, well, you're the owner of the company, right? Or you're the successor in interest to the company. So we can see why you would be bound to these. But what we're talking about here are people that, they're unaware of the contract, they're unaware of its terms, there's no direct sort of benefit, or they're not designated third-party beneficiaries of this contract. So you're roping in all these people into having to comply with contracts that they, know nothing about. Now, there's some evidence that the letter was sent out later to JTL just saying there is a contract and describing some of its terms, but it didn't actually add the language. It didn't include the entire contract. So the problem here is the way the court came out on both the personal jurisdiction issue, if it did base it on this closely related doctrine, and on the jury trial issue, is that it's gone too far, or it seems to be going too far. One of the district courts, I think, summed it up well, that it's getting to be a little vague, too vague, where it's becoming sort of an unworkable standard.
This is what the Texas Supreme Court says, that in such circumstances, enforcement is permitted if the relationship between the non-signatory and a signatory to the contract is close enough that the non-signatory's enforcement of the forum selection clause would be foreseeable.
Right, and that sort of leads...
Why is it not foreseeable here?
That leads to the second part, is from what I understand from precedent out there, is we sort of measure foreseeability in terms of when the contract was formed, right? You were intimate with the terms of the contract, and you would know that would potentially apply to you. That doesn't, that's not the case here. And in this sense, and the court said on multiple occasions that, it's rare that it wants non-signatories to be bound to contracts, especially ones that they are unaware of and don't know the terms of, right? It's really rare that you want to do this. The problem is if this court sort of adopts this sort of inextricably intertwined version of this closely related doctrine, you're going to snare a lot more. And that's contrary to sort of the court's belief that it should be rare. And let's think about this. The court has pointed to both law of agency and law of contract many times in this arena. And the reason it does is because we don't typically expect somebody that doesn't know the terms of a contract and sign a contract to be bound by it. We all could be bound by contracts that we don't know about. And the other problem is agents. So even if they are an agent, and in this case, of course, we argue that there's not the evidence to support that. But even if you are an agent of a company, well, typically law of agency says, well, just because you're an agent doesn't mean you're bound to your company's contract that it formed, right? Because any president, CEO, anybody who signs a contract would be bound to its terms. And I don't think the court wants the net to be spread sort of that far. It looks like I'm sort of running out of time here. In my last couple of minutes, I'd like to talk about the trial of the district court's decisions on damages and the attorney's fees. And the first is a purely legal issue. One is this double recovery where the court awarded about $147,000 in future damages, and then this overlapping injunction saying you can't compete and you basically can't create revenue. So it's this double recovery, and whether it's federal law or Texas state law, courts don't like double recoveries because you're giving people too much. If they have an adequate legal remedy, you give them one or another. This court has, I think it was Next Level Communications, this court has said that a trial court didn't abuse its discretion when it wouldn't allow this kind of double recovery. There's at least one case from another circuit, I think it's the federal circuit, that says you can't have this double recovery. And then you've got Texas Supreme Court law. You're going to hear about probably Texas Business and Commerce Code 15.51 that says you can have damages and injunction. But then you also see that since that has been enacted, the Texas Supreme Court has looked at it and said, well, you still can't have a double recovery in these situations. Now, they might cite this case that was decided later in the intermediate appellate courts, although its facts are completely different. That was a trade secret that was never supposed to come to market, so it wasn't duplicative, right? The recovery wasn't. So one question maybe you reserve for the other side here is how, isn't this duplicative? And this is purely a legal question, so I think that the court can review this de novo. Looks like I've got about 20 more seconds. Does the court have any more questions?
Let me ask you about the last point you made about the injunctive relief and future damages. Could it not be that if the plaintiff has lost a customer, the plaintiff would recover both the past damages, that business that it would have received from the customer until the customer had been swayed over, allegedly by improper means, and the future damages that the customer was still doing business with the other defendant. You understand what I'm saying?
Yeah.
As well as injunctive relief that thou shalt not do that again or into the future. And in the meantime, we lost business from a customer who has now chosen to enter into a contract beyond the date of the judgment. Yeah. Is that a possible scenario?
Well, I don't know. I think most things are possible, right? I don't think that necessarily occurred here. And if you're complying with you have relief. If they're not continuing on with this customer, they're not complying with the injunction, right? And so you've got relief around that injunction.
I'm asking conceptually because your argument was that they're mutually inconsistent and it's not appropriate to award both forms of relief, but in that circumstance it would be, and I suspect that's what the argument will be.
Well, they haven't argued so far about why it's duplicative. You may have clued them in on
I'm sure we'll hear from counsel.
A potential argument. I think it's still, it's just overlap. How do you police that, right? One way is you say they're violating the injunction based on this one customer, and then you can police it that way, and you can get relief. You can still get relief. So I don't think you're losing out. I think it has to be one or another, and I think that seems...
But the statute says damages. If I read it correctly, if I recall, the statute says damages. It doesn't indicate between future...
It doesn't, and it doesn't say that you can have a double recovery, right, either. And as we know, courts don't like double recoveries because it's a windfall. It's a windfall.
Yes, you've saved time for rebuttal. I will let you pronounce your last name. I'm not even going to try.
Certainly, Your Honor. Good morning. My name is Frank Sciremammano. May it please the court. I'm arguing here on behalf of appellee Franlink, Inc., and there's several issues at stake in this appeal, but I'd like to focus the court on the issue that Judge Jolly raised, and that's whether the non-signatory defendants are bound to this franchise agreement, in this case, in the Forum Selection Clause, the personal jurisdiction waiver, and the jury trial waiver. Your Honor, the district court found that the non-signatory defendants are bound by the franchise agreement in this case, and the personal jurisdiction waiver, and the Forum Selection Clause, and the jury trial waiver, under several legal theories. But I want to review some record evidence for the court showing how they are one and the same, because ultimately the district court's findings of fact indicate that the non-signatory defendants are essentially one and the same with Bace Services and Craig Wells and Amy Pope Wells, who are the franchisee defendants in this case, Your Honor. From 10,000 feet, one day this franchisee was operating its business in Florida as a Link Staffing franchised business. The next day, it's like they flipped a switch, and all of a sudden they were operating as JTL Staffing and Employment. Craig Wells, the owner of the former franchisee, was involved in the establishment and management of JTL. How could he not be? They flipped the signs overnight. And his stepson, who was the manager of the former franchisee, immediately became the manager of this JTL entity in Florida. And they operated these businesses, Your Honor, interchangeably with the same employees, the same clients, and the same field staff, who are the temporary employees who they send out into these businesses to perform the work. So, Your Honor, Craig Wells, Bace Services, and JTL's Jacksonville operations, they were one and the same. And the district court cited a lot of documentary evidence and the defendant's own conduct in this matter in its findings of fact. And the defendants don't contest any of those facts in their briefs, Your Honor. None of them. So I want to highlight some important ones. Record on Appeal 5476. That's a letter that the defendants sent to clients. It said, quote, Bace Services Incorporated will no longer be doing business as Link Staffing Services from 10/21/2019, which is before the franchise agreement was terminated. Bace Services Incorporated will be doing business as JTL Staffing. And that letter was on JTL's letterhead, but it included the same address and the same telephone number associated with the former Link Staffing franchise business that the Bace defendants operated. That's all the court needs to affirm the district court's ruling that the non-signatory defendants are bound by this contract. It's their own words, Your Honor. And there's a lot more evidence. Record on Appeal 5685. That's evidence that Craig Wells solicited his largest and most profitable client to do business with JTL and terminate its agreement with Link Staffing. That same client also testified at trial that Craig Wells served as the point of contact for both JTL and Link Staffing. There was other evidence, Your Honor, that Craig Wells was managing and operating JTL's business. You can look at Record on Appeal 5469. That's an email showing Craig Wells visited and delivered payroll information for field staff on behalf of JTL. Record on Appeal 5494, Your Honor. That's an email deferring to Craig Wells regarding his stepson's compensation at JTL. Step back. Why would JTL defer to Craig Wells, the former franchisee, regarding his stepson's salary at JTL if he wasn't involved in the management and establishment and essentially running this business from Florida, Your Honor? There's also evidence in the record that the defendants, in their own words, stated that this transition to JTL was simply a name change and nothing more than that, or a
District court found that? Is that what you're saying?
Yes, Your Honor. And the district court cited all this evidence that I'm reciting for you. It's cited in the district court's findings of fact, and the defendants haven't taken issue with that evidence, Your Honor. So you can look at Record on Appeal 5471. That's an email that the defendants sent to their clients, and they said, quote, all invoices going forwards will be from JTL Staffing instead of Link. Rates and terms are the exact same. Record on Appeal 5474, another email. It says, quote, office team is remaining the same, and so are the terms we had in place. The only real change is the name change. Record on Appeal 5742. That's an email from a client. I'm sorry, Your Honor. Record on Appeal 5478. That's an email where they say the DBA is changing, the doing business as is changing. This was simply a name change, Your Honor. And there's also record evidence that the customers themselves in the Jacksonville market where this business was being operated, they were confused. They didn't know who this other business was. They didn't know how to distinguish between the two, and they had to actually ask Craig Wells who was who. Record on Appeal 5526.
What did Craig Wells say?
What was that?
What did Craig Wells say when asked the question you referred to?
So that evidence, Your Honor, is not in the record, but I'm assuming, well, let's step back. Craig Wells, he solicited their Bace's largest client to go over to JTL. So I think what he was telling clients is, I'm no longer Link Staffing, I am now JTL.
He's in bankruptcy now.
Correct, Your Honor, and they've settled out of this case.
He's not a party in this appeal.
Correct. But Your Honor, the point remains that the customers were confused, right? They couldn't even distinguish these businesses. Record on Appeal 5526, that's an email from a client asking Craig Wells who to pay. Should I pay JTL for these services or Link for these services? I'm not sure which company was responsible for providing these services. Record on Appeal 5563, that's evidence that a client in the Jacksonville market actually paid the wrong vendor. I think they paid Link instead of JTL. They paid JTL instead of Link when the other was providing the services. Record on Appeal 5742, Your Honor. That's another email asking Craig Wells which company is responsible for paying this certain employee. So you can see it's a continuation. That's the point here, Your Honor, that the non-signatory defendants and the franchisee defendants are one and the same. And this JTL staffing business is just a continuation of their franchised business.
Taking your argument, it seems to me that this is solely a question of fact. Now, you're given the principle, and then it's solely a question of fact. Does this support the principle of closely related or, as I think Texas refers to it as the transaction participants. I don't know. What is the difference between transaction participants that are closely related?
Well, to answer your first question, Your Honor, it is highly factual. I mean, this case was about the facts. We had to issue, I was one of the trial counsel, we had to issue 20, 25 subpoenas just to gather all this evidence, Your Honor. I don't think that the courts have really distinguished between transaction participants and closely related and intertwined. It's kind of one of these things where you know it when you see it, right? It's a clear continuation of this business. And I think the fact that
The problem that I have with it and is that this is essentially, seems to me, a tort case. Tortious interference with the contract. And yet it's being presented to us as a pure contract case, contractual liability. And there seems to be a thin line between that. I mean, these people were obviously committing tortious interference with the contract. But it seems, and that would be easy to prove on the evidence you've got now. But that would not get you in jurisdiction of the Texas courts. That would be something to pursue in Florida. So you pursued this business of closely related to get them in the Texas courts. I mean, I guess it's a factual question as to whether you satisfy that theory of closely related.
Well, Your Honor, if I may, I think courts have made clear, including in the Fifth Circuit, and let me back up, this was a hybrid case, right? It's a tortious, it involves intentional torts, and it also involves breaches of contract. And it's a non-compete dispute, and these sorts of things, the end of the franchise relationship can give rise to these sorts of things because you have a franchisee trying to play shell games with various corporate entities to keep his business going and avoid a non-compete obligation in a franchise agreement. So that's a relatively common scenario, Your Honor. And so courts have made clear.
Now, all of this did not occur. I mean, a little of it occurred, I think, while the contract was existing between Bace and Link. But it's primarily all of this occurred after that contract ended, and they were stealing the clients of Link and transferred them to JTL and others. And that would be tortious interference with the contract.
But for, Your Honor, that the former franchisee was involved in this, and the former franchisee, under the franchise agreement, got access to Link's clients. They got access to the employees. They got access to the trademarks and the confidential information. And at the end of the relationship, the non-signatory defendants essentially retained all that. It was essentially transferred to the non-signatory defendants with the former franchisee operating and managing this business. So the
all these defendants were engaged in a conspiracy to take all these clients and put them somewhere else with the signatories to the contract. And yet these tortfeasors now are being alleged as parties to non-signatory parties to a contract that they never signed and that they didn't really benefit from until the conspiracy to interfere with the contract occurred and they started shifting clients away. I mean,
But
it's confusing to me. I mean, the theories, the two juxtaposed theories.
Sure. Well, I think that the retention of the benefits by the non-signatory defendants, that the clients and the employees were transferred to them, that's enough to bring them under the guise of this contract, Your Honor, because they were it's one and the same. These defendants were operated interchangeably, so the non-signatory defendants they retained those benefits, and while it might have been at the very end of the contractual relationship, that's arguably the most important time.
From the contract. They benefited from the breach of the contract. How did they ever benefit from the contract as long as it was alive that would have bound other signatories to it?
But for the contract, they never would have had access to the clients. They never would have had access to the field staff. They never would have had access to Link's trademarks. And they never would have had access to Link's confidential information, Your Honor.
Yeah, but this is like someone who is a participant in the contract and decides to leave and form his own business. Well, I mean, is he liable to the contract that he left to form his own business as a non-signatory because he benefited from it?
If there's
That
not,
doesn't make sense, as I understand the distinction between tortious interference of the contract and a non-signatory being liable to the contract as though it were a signatory. I mean, it's...
well, Your Honor, I think that the hypothetical you raised is distinct from this matter insofar as there are a lot of post-contractual obligations, post-termination obligations in this contract. The franchisee wasn't allowed to use Link's confidential information following termination of the franchise agreement. There was a strong non-compete, a broad non-compete in this franchise agreement that the franchisee had to abide by. It was a 2-year non-compete. So I think it all kind of meshes together, Your Honor, but the non-signatory defendants absolutely retain the benefits of this franchise agreement. Look at it this way. The benefits of the contract did not go back to the franchisor, right? That's how these franchise agreements operate.
Okay, but again, tell me, you have told me a little bit about this, about how did they benefit from the contract itself? Not the breach of the contract, not the torts they committed, but how did they benefit from the contract so that they would be bound to the contract even though they never signed it?
Sure. The former franchisee learned how to run a temporary staffing agency under this contract. Everything he learned about how to run a temporary staffing agency was the result of what the franchisor trained him. So at the conclusion of the contractual relationship, this franchisee worked with the non-signatory defendants to retain those benefits. And so it's through the former franchisee, Your Honor, that the non-signatories retain these benefits from the contract. It's the fruits of the contract, Your Honor, using the trademarks. There's evidence in the record of JTL using one of Link's proprietary assessment forms.
As I understand your answer to, is the benefit they received is the knowledge of how to steal clients to transfer to somebody else.
No, Your Honor, how to run a temporary staffing agency.
Well, I guess that would be part of it. I mean, how to, they would have to know the clients, that's certainly true. But that's not a benefit to them until they decide to leave, or until they decide to commit the tort. So they don't become a non-signatory until they apply their knowledge to commit a tort. And I mean, I can't quite wrap my head around all that.
It is. Well, these cases, Your Honor, they're highly factual. They're very fact-specific. And there's a number of theories under which the non-signatories can be bound. It's estoppel, right? It's agency, and it's also this intertwined theory. And I think they all kind of, they play together. But in these franchise cases, and we cited a few in our brief, Your Honor, the Novus case, for example, that court enforced a jury waiver against a non-signatory corporate defendant with a close relationship to a former franchisee. Courts recognize that in these circumstances where you have a former franchisee playing shell games with corporate entities, that the other corporate entities that they're playing shell games with to avoid their contractual obligations are also bound.
They didn't have contractual obligations, did they? I mean, in other words, they didn't become a liable non-signatory until after the contract was formed and not until they decided to commit a tort. And if you'd brought this case in Florida, you would have had a strong tortious interference case. But you don't want to do that. You want to bring it in Texas where you have your forum selection clause and abandon them to the forum selection clause because they committed torts in the dissolution of the franchise as a result of no benefits that they received other than their experience as an employee. I mean,
Well, not just experience as an employee. This former franchisee was a business owner, Your Honor. He managed and established this business in Florida. He ran the business, and that's very valuable knowledge. But
Morton?
well, I'm sorry, what was that?
You're talking about Morton? Who are you talking about?
I'm talking about Craig Wells, and I'm talking about Morton, yes.
Oh, we know, but you're not talking about the people in the bankruptcy now. You're not talking about the original, the signatories of the contract.
No, I am talking about them, Your Honor.
Well, then you don't need the theory of non-signatory liability if you're saying the people that if they're bankrupt, they are out of the case now. You can't get anything on them right now, can you?
Correct. That's absolutely correct, Your Honor. It's the non-signatories at issue here, Your Honor. I think in this kind of circumstance, Your Honor, and to back up, let me back up, because I think you said it wasn't until the contract ended that these benefits were transferred. There was an overlapping period of time. The franchise agreement was not terminated until November 6th, 2019. And the evidence in the record shows that the defendants were transferring clients and employees to the non-signatory defendants before that date. There's an invoice by Bace's largest client, which was sent to them by JTL with an effective date of October, I believe it was 21st, Your Honor. So there was a transfer during the contractual period, and I think the court shouldn't overlook that, Your Honor. I think in this kind of circumstance, holding the non-signatories to the franchise agreement makes sense from a policy perspective, Your Honor. Franchisees trying to play shell games with corporations.
Now, if you begin to concede that this is a policy question, then you're conceding that you don't have a legal question.
No, Your Honor, I'm simply suggesting that.
You can't make policy for the state of Texas.
Understood. Absolutely. And I'm merely suggesting that this question hasn't been addressed in these specific circumstances by the Fifth Circuit, and it makes sense to affirm the district court's holding in this case. And I see I'm almost out of time.
Well, let me ask you, on what specific law in Texas do you rely on for this closely related theory?
It's the district courts in Texas that have applied. I'm sorry, it's the Helnick case, Your Honor. The Helnick case under the Fifth Circuit, which allows, that was a seminal case by the Fifth Circuit that allows non-signatories to be bound by arbitration agreements.
Arbitration case.
Yes, and we submit that this is a natural extension of that. Thank you, Your Honor.
Mr. Tomlinson, for rebuttal.
Just to sort of dovetail on to the end of that, Judge Jolly, I think your instinct is right here. However, the benefit that they're discussing about knowing how to be a staffing company wouldn't apply to JTL Staffing and Payroll. It's in the record that they're an existing company that was competing with Link in Florida already. Obviously, they knew how to do that. One thing that I do want to correct is we do contest some factual findings, especially the one the counsel just discussed about Craig Wells being a manager and establisher of JTL Staffing. And we've argued in our briefing that that's clearly erroneous. The evidence that the court supports that with in the factual findings, the court discussed a Facebook post about transparency, and that shows that he manages and establishes. Well, JTL, it's in the record also. JTL is an Alabama company. JTL's been around. There's not sufficient evidence here, and it's definitely clearly erroneous. Even if there were a little bit of supporting evidence, the court could see that could form a definite conviction that a mistake had been made in this case. So we do argue against some of the factual findings, and that's really one of the big.
The factual findings.
Yeah, we don't. I mean, obviously, we don't argue all of them. And you can look in the briefing. We just discuss some of them. It doesn't mean we agree with them. It's just we have X number of words in our brief to talk about things, so we concentrate on things that are material.
We will know by reading your brief what you're appealing and what you're not appealing.
Well, in terms of factual findings, when we discuss typical and yes, what we're appealing, and absolutely what we're appealing and what we're not appealing. I just want to make this point about jury trial waivers. If this court affirms the district court on that point, it will be the First Circuit Court that does so. Now, there are some courts that have said you can do it, but the cases that were cited were out of the Third Circuit, and they were decided before Tresinda was decided, and from the Tresinda opinion, you can see that they wouldn't agree with those district court cases. It's something to keep in mind. You'd be sort of a forerunner here on that point if the court does.
That's your primary argument. You're kind of ignoring the things that we've been talking about.
Well, which one? The personal jurisdiction?
Your primary argument is that notwithstanding the fact that as a non-signatory I may be bound to this contract, and you almost accept that, as I understand your argument and your brief, but that does not mean we are bound by the decisions that they make at trial, such as waiving the jury trial. That seems to be your line on that.
Well,
Reverse this case, you want to reverse it on the basis that you were denied a jury trial.
I want to reverse it on a couple of bases. One, the jury trial as it applies to JTL. The other, personal jurisdiction in venue as it applies to all the non-signatory defendants who are Morton, Payday Solutions, and JTL, the people who didn't sign the contract. You know, we're also asking for relief around the attorney's fees and the damages too. It's a lot to get into today. I'm going to try to avoid doing so at least. In terms of the closely related piece, there's a legal piece and there's a factual piece, right? And we argued in our briefs that the court shouldn't apply this doctrine, but even if it did, the trial court still made some errors here. It didn't get into foreseeability. There were no findings around that, and it didn't consider all the factors that you need to consider around foreseeability. So yes, we're saying that this, and I believe you're hinting to this too, this really is a case that should have been filed in Florida and not the Southern District of Texas.
Well, from your point of view, that may be true, but not from their point of view.
No, absolutely not, but I think the law supports that. I think the record will support it also. So anyway, even if you do apply this closely related doctrine, the trial court still didn't give you enough information to get you there, whether it would apply here and bind these non-signatories in this case. And other courts, mainly district courts, you've seen cases that I've cited out there. There's one newer case, but it just says the same thing. You know, they don't want to apply this closely related doctrine. I think, honestly, it just creates a problem. We are ensnaring more non-signers to contracts and agents into these terms of contracts, which, you know, they didn't agree to, they didn't know about, but now they're responsible for the obligations under, and I think courts are hesitant to do that. Does the court have any more questions?
Thank you, Mr. Tomlinson. Your case is under submission. Last case for today, Collette versus Weyerhaeuser.